Your vote doesn't count. Not because of election fraud, though that may have occurred in the recent past, but because of how far too many government officials act once they're in office. America is a republic. In a republic, you vote for representatives. U.S. senators, congressmen, state legislators, the list goes on. These representatives are the people who make law, and your vote counts when the laws they make are interpreted as written. But what if each time a law was interpreted, as in a court case, someone who you didn't vote for got to say what it meant? What if they got to decide how it should be interpreted or what it was really supposed to mean? That person, the judge, would have almost all the power because they would decide how that law impacted the parties in the case. If this was the situation, it wouldn't matter what the legislator wrote when making the law. And your vote in electing that legislator wouldn't matter either. Unfortunately, this situation is not hypothetical. This is the case in America today. Judges do have this much power. And when the judge presides over a federal court or even the United States Supreme Court, their decision not only impacts the parties in the case, but it has the power to change the entire nation. When these judges do not interpret the law according to the law's text, they essentially rewrite laws made by the people's representatives, and they rob the people of a voice in their government. In such a situation, how can democracy be preserved? Well, we must first interpret the United States Constitution as it is written, as the document which lays out the role of judges as interpreters, not revisionists, and dictates the proper function of the entire U.S. government. Only then may judges be compelled to preserve the laws as they were written by the people's representatives. Therefore, by insisting that judges interpret the Constitution according to the text, Americans can make their voice heard and better order their government to resolve the many conflicts dividing their nation today. First, I will walk through why we don't simply just use Scripture, why the federal government does not simply govern the nation itself without the states, how we can all agree things need to change, why we still need to look at the rules of the past and not throw them out, the best way forward being those said rules, and then finally, what you can do as American citizens to better your government. So, before a Christian makes any argument to use a secular document to do something as important as the job of government, they should see whether we should use Scripture first. They should also heed a church father's warning against doing this. That church father was Martin Luther, and he explained Scripture's explanation of church and state as a doctrine of two regiments. Estelle Theological Seminary professor Yui Swarat is a Lutheran and explains it like this, quote, "One cannot rule the world with the gospel. One can only teach the conscience with the gospel. One may not interrupt the business of government with it. The authorities should have no power over the faith and conscience of the people," end quote. Luther says that the doctrine of two regiments involves a spiritual regiment, which includes only believers and signifies Christ's special lordship over those believers, and a temporal regiment, which includes non-believers as well, who do not have Christ's special lordship over them. He argues that they should be kept separate. And this is also supported from a historical perspective. Quote, "In the specific historical encounter between state and church," Swarat says, "the power in the regions of the Eastern Church has strongly shifted towards the state, so that the intended symphony of two independent entities has become a rarity. The state has a say in determining the order of the church, as well as the direction and extent of its actions. That means that the threat of a church-state unified model is not that the church will exert too much power over the state, but rather, when any church tries to do so, the state will grab hold of it and strangle it with an iron fist. James Madison, another figure from history and an important founder of America, also agreed that church and state should stay. Quote, in 1832, President James Madison wrote, "It might be difficult to always maintain the line of separation between religious and civil authority." He added that he thought the best way to do so was to keep the government from interfering religion in any way other than to preserve public order and protect the rights of each religious sect. End quote. As a religious man himself, a devoted Christian, and someone well-versed in law, Madison knew the possible benefits of a Christian nation, and yet he still understood that the best way forward for America would be to keep these two regiments separate. So, America should take the advice from Scripture, learn from human history, and structure our government according to the Constitution. Well, exactly, some of you might say. The church shouldn't run the country, the federal government runs the country. Well, that still misses the mark, because the federal government should not run the country alone. It should do it in concert with the states. Deputy General Counsel for Stockton University, Ellen Bailey says, quote, "As the colonies unified into a singular nation, the protection of religious freedom was penned into its founding documents." In fact, Article 6 of the Constitution, adopted in 1789, forbade a religious attest for any federal public office or public trust. At that time, 6 states still had established religion, and Virginia had just passed a law establishing religious freedom. However, none of the new states wanted federal interference in these matters. End quote. Just as the states wanted church influence out of the government, they wanted federal government influence out of such important matters like religion. The reason behind this was they believed in the dual nature of both good and evil. They understood that power concentrated in any central authority would be an evil, so they sought to spread it out through as many people as possible. Legal scholars like James Madison, as I have mentioned, as well as Supreme Court Justice Antonin Scalia, agree. And they also go on to say the federal government has no legitimate authority to function outside the U.S. Constitution, which limits it to working together with the states. Professor Jeffrey Morrison explains this hierarchy of the Constitution over the federal government led Madison and Scalia after him to privilege the interpretation of the Constitution given it by the people through the ratifiers, and to insist on a fixed meaning given it, always leaving room for legitimate change through the amendment process, which is ultimately an exercise of popular sovereignty. Well, that is a lot to unpack, but essentially it means the people are those that control the government, or at least they should be, and they control it through the rules they made in the Constitution. So, please follow the Constitution, federal government, rule with the states, not by yourself. Don't ignore the people in a government by the people, for the people. In fact, America's citizens even passed an entire amendment to make sure the federal government understood this, which is Amendment 10 of the Bill of Rights. It reads, quote, "The powers not delegated to the United States by the Constitution nor prohibited by the states are reserved to the states respectively, or to the people," end quote. If the federal government did not already understand that enumerated or listed powers in the Constitution were the only powers they were given, Amendment X reminds them of that fact. Simply, if the government ruled not by Scripture and not by itself, but in concert with the states, following the United States Constitution, people would have much greater voice in their government. Whether or not you agree so far with what I have said, we can all understand that there is currently a power gap between the people, who I would argue have about 1% of the power, and the federal government with 99. All we need to do to see this such a big difference is look at how little power individuals and the states, which represent the individuals, have in the current system. Political reporter Rob Boston says, quote, one such measure passed with 62%, the vote making Nevada the first state to protect marriage equality in its constitution. This type of protection could become important if the U.S. Supreme Court overturns Obergefell v. Hodges, the 5-year-old ruling declaring marriage equality a right under the United States Constitution. If that happens, then the matter will revert to the states, end quote. Although the issue of gay marriage is a complex one, and one everyone seems to have quite a bit to say about, we, the people, the citizens, and even our states, don't get to have a say on it because the Supreme Court has made that decision for us. In fact, if things were the case and things followed the Constitution, state legislators would have made the decision to legalize gay marriage. And they would have been exercising their legitimate reserved power to legislate all matters not delegated to Congress as per Amendment 10 of the Constitution. That would have been okay. And if that were the case, you, the citizens, had you not liked what your state had decided, could petition your state legislators to change that law, or even ran for office yourself. Essentially, you still had a voice in your government. But because the Supreme Court has made this decision, in a case it had no right to hear, because it may only hear a select few types of cases, most of which concern laws arising under the Constitution, according to Article 3, Section 2. Because it heard this case that it did not have a right to hear, the only thing that can change this so-called law legalizing gay marriage is another case making it all the way to the Supreme Court and then being decided by those justices, the same justices, in an entirely opposite fashion. Now, that's just not going to happen. Clearly, there is injustice within the structure of the current American government. So, what do we do about it? Well, America still remains divided on how to deal with such structural injustices. Some say, well, the Constitution is to blame. It's rules of the past. We need to let these die out and then take a more pragmatic approach to making rules for the future. While others would say, hey, we simply need to go back to how things were. If we followed our Constitution, all of this bureaucratic, problematic stuff would simply go away. Richard Posner, former Chief Judge of the United States Court of Appeals and one of the biggest proponents of that former group, the legal pragmatists, says, after all, quote, the goal of a new bankruptcy statute, for example, might be to reduce the number of bankruptcies. And if the statute failed to fulfill that goal, it would be repealed. If this were the case, law really would be a method of social engineering. Much like the structures and designs susceptible to objective evaluation, like the projects of civil engineers. This would be a triumph of pragmatism, end quote. I agree. This would be a triumph of pragmatism, getting essentially judges to check Congress's homework and make it better. Seems exciting even. However, the judiciary was not established as homework checkers for Congress. They were established for a different purpose. And Supreme Court Justice Scalia often responded to such short-sighted comments like this with questions like these. When did the American people vote on X? Why should an unelected panel of judges get to change the meaning of a text without going through an amendment process or having Congress pass a law? End quote. Under the Constitution, instead of unelected single officers like judges getting to decide what is best for the nation, elected dual committees of Congress, made up of the House of Representatives and the Senate, get to decide that. If judges did not follow Posner's pragmatist model, as we see here, and end up changing the law that the people's representatives made, the people would get to keep their voice in government. Some people might press on, saying, well, you still can preserve the whole ideal of pragmatism if you simply interpret the law based on lawmakers' intent. After all, people voted for the lawmakers, so what the lawmakers want is what the people want. I had the privilege of speaking with Ohio Supreme Court Justice Sharon Kennedy, who disagrees with such short-sighted claims. Please allow me to paraphrase her here. She said, I would certainly call myself a textualist, like Justice Scalia, because as soon as you try to interpret the law based on what the lawmakers intended, you run into problems. Imagine that you and I both were legislators who voted for a statute. At the end of the day, I walked down the Capitol steps to my car whistling, thinking that I had enacted a law to do one thing. You walked down the steps to your car whistling as well, thinking you had enacted that same law to serve a different purpose. Then whose intent is right? That is why you have to look at what the law actually says, what the lawmakers actually wrote right there in the text. As Kennedy so aptly explained to me, allowing judges to interpret based on the people's will, the lawmakers' will, you allow judges to misconstrue what the citizens actually want, since that legislator's intent is often very, very ambiguous. So, legal pragmatism seems like quite an effective way to govern America, but it really isn't. The answer lies with the constitutional model, seen here. So, I'm sure everyone is wondering at this point, how do these constitutional principles measure up in the real world? Well, the landmark Supreme Court case of Tennessee v. Lane is how Americans' lives will improve if proper constitutional interpretation is applied. Allow me first to summarize the facts of the case. George Lane and Beverly Jones were the respondents. They were paraplegics in wheelchairs. And George claimed he was unfairly jailed for failing to appear at a hearing that he had simply no way to get to. It was on the second floor of a courthouse with no elevator. Beverly Jones similarly claimed, because she was a court reporter, she had missed the opportunity to work and participate in the judicial process. Because, also being in a wheelchair, there were many courtrooms in courthouses without elevators. Both sought damages and equitable relief under Title II of the Americans with Disabilities Act, or the ADA, which provides, quote, no qualified individual with a disability shall, by reason of such disability, be excluded from the participation or denied the benefits of services, programs, or activities of a public entity, end quote. The state of Tennessee chose not to be amenable to Lane's lawsuit against them because of their state sovereignty under the 11th Amendment interpreted by the Supreme Court in Hans v. Louisiana. In response, the United States Congress abrogated or temporarily took away Tennessee's sovereign right to not be amenable under Section 5 of the 14th Amendment. This posed the question, was Congress right in doing so? Well, Supreme Court Justice Stevens issued the court's opinion. Congress did act pursuant, and they were right, because of the 14th Due Process Clause concerns the Title II of the ADA. This would be fine if this Supreme Court case only affected those parties involved, but it doesn't, as every Supreme Court case does. It affected the entire country. Former Texas Assistant Attorney General John Bible predicted that in the future, quote, issues all over the country will involve external access to some courthouses with rooms, what Title II requires in older buildings without elevators, what accommodations of the disabled are reasonable, and whether particular modifications of buildings would unreasonably compromise their historical integrity. Whew, it's a lot to worry about. So no wonder states are always sitting on pins and needles nowadays, binding up public and private projects with accessibility red tape. After all, they could be sued should something go wrong. Had the Supreme Court gone a different route and agreed with Supreme Court Justice Scalia, they could have prevented states being so worrisome and making so much red tape. His dissent analyzed the meaning of the law's text, specifically the word enforce, and concluded, quote, what Section 5 does not authorize is a so-called prophylactic or preventative measures, prohibiting primary conduct that is itself not forbidden by that 14th Amendment, end quote. That is a lot of legal jargon to take in, so Scalia broke it down with an analogy. Quote, one does not, for example, enforce a 55-mile-an-hour speed limit by imposing a new 45-mile-an-hour speed limit, even though that is indeed directed to the same end of automotive safety and will undoubtedly result in many fewer violations of the 55-mile-an-hour limit. That's just not what enforce means. Had the Supreme Court agreed with Scalia's dissent, they would have kept necessary regulations with the ADA, but also expressed their intent to keep excessive regulations from ever being written. So, the Constitution does not just force the government to abide by its own rules. Properly interpreting the Constitution can really make life better for American citizens. Simply put, a United States government which will adhere to the Constitution would give the power back to the people and solve many of the bureaucratic problems plaguing America today. Instead of trying to modify our republic, which usually leads to increased cronyism, or throw at everything and start from scratch, which usually leads to totalitarian rule, America only needs to return to our well-designed system laid out in our Constitution. If we did that, more than just the presidential election would matter, because judges wouldn't repeatedly overrule what the people's representatives make as laws. I understand not every person here works as a federal judge. In fact, I bet none of you do. So what can we, the American citizens, do about it? Well, we can vote. We can take the advice James Madison offered us all those years ago in Federalist Paper number 57 and remind our representatives that they are dependent on us, the constituents, for our loyalty and support, so they are compelled to remain faithful to the Constitution. In essence, you only vote for legislators, judges, and presidents who mean it when they swear to serve and defend the Constitution, who believe the document is what it is in the text. If you aren't sure about a candidate, write them a letter, send them an email, or give them a phone call, because if each of us made our representatives care about the Constitution like this, we would transform the nation. If we did this, we could make our votes count. Thank you.